I wanted to do a little bit of a viewer's guide for tomorrow's all-important oral argument at the Ninth Circuit Court of Appeals about Donald Trump's illegal federalization of the National Guard. The violation of California's sovereignty is up for grabs. The hearing, the oral argument for the Ninth Circuit on quick briefing about whether Judge Breyer below, Charles Breyer in San Francisco, was right or wrong in the temporary restraining order mode to have granted a temporary restraining order, finding that Donald Trump committed illegal acts, unconstitutional acts, and returning the command of the National Guard over to Governor Newsom. The question is whether the court is going to stay the order of the temporary restraining order for the duration of the appeal, however long that lasts. Are they going to interfere at all with Judge Breyer's actions below? Because he's got a hearing on Friday about the next level up in the injunction world, the preliminary injunction. What's going to happen at this hearing tomorrow? We're going to cover it at 3 p.m. Eastern time here on Legal AF under the tab Live. I want to talk about the three judges. I want to talk about the procedure so that you understand what is at stake tomorrow and why it's so important. Okay, you're on Legal AF. Take a moment, subscribe so that you'll get the reminder for the live tomorrow. And I'll be inside the live chat giving commentary along the way. All right. How do we get here? Last Friday, Judge Breyer issued a temporary restraining order, finding it was more likely than not that Donald Trump committed an illegal act. He violated the militia law of 1903. He violated the 10th Amendment, which reserves power to the state that's not given to the federal government by act of Congress, law, or by the United States Constitution. Because Donald Trump violated the 1903 Militia Act, because there was no rebellion, he doesn't have any difficulty executing his laws, and therefore he did not go through the governor, and therefore he could not commandeer the National Guard. That's a good thing for state sovereignty. That's a good thing against Donald Trump's retaliatory attacks of a political rival and the rest. That normally would sit in place for maybe a week or two until the judge gets around to full briefing. The record is better developed, the fact record, and we have our preliminary injunction hearing. That's the next rung up on the ladder. That hearing is set for Friday. The judge already set a fast briefing schedule, but Donald Trump, that wasn't good enough. So he ran and complained to the Ninth Circuit Court of Appeals. 3-judge panel randomly assigned. 2 were appointed by Trump, with one with an asterisk. One is a Trumper, Federalist Society, although he has ruled against Trump in the past. One is a moderate coming out of Hawaii, and one is a Biden appointee. And they gave an administrative stay until they can have full briefing and an oral argument on Tuesday, which we're going to cover here again on Legal AF under the tab Live. All right, briefing is happening. Who are the judges? Because they're really important. First, let's start with Judge Eric Miller, the most controversial of the three. Came out of California to be appointed to this intermediary appellate court just below the United States Supreme Court. Eric Miller was a Clarence Thomas law clerk. I think that's all you need to know. I'll leave it at that. Right-wing Federalist Society, super conservative, MAGA. Donald Trump thought it was a safe pick. The 2 senators at the time of his own state objected to his being appointed. They withheld their blue slip. That's an old-timey way that senators could object to a candidate for federal judgeship. They didn't blue slip him. So over that objection, and with almost nobody in a committee, he was approved effectively by 2 senators to go to the House floor for a simple majority vote, because the Republicans under Mitch McConnell changed what had been for the Democrats a 60-vote confirmation requirement, at least 60 votes in the Senate, to a simple majority 51. He gets in. Everybody's all excited in Trump world. Another Clarence Thomas clerk. He's in. He's generally been on the MAGA side. However, he has talked about the importance of the independence of the judiciary. So even he has to be given some sort of pause when Donald Trump goes out and bashes the federal judiciary. He might say, well, he's not bashing me. But if he's looking honestly at the judiciary and its role in our constitutional republic, that has to give him pause. He's only had one case or so against the Trump administration in the first term about immigration, and he did not side with Donald Trump. But I would not put all my marbles into Eric Miller's bag, if you know what I mean. But he's got two other judges that are up there with him. On the other end, you've got Judge Jennifer Sung. She is she's about as liberal and to moderate as you're going to get. She worked her entire career for workers' rights and labor rights, representing labor unions and workers, organized workers in her career. She started on a scholarship where she worked for the Brennan Center of Constitutional Center in New York, named after a famous Supreme Court Justice, William Brennan, which is liberal to moderate. She was there on a scholarship from a law firm I used to work at. She was a Skadden Fellow at the Brennan Center. She then worked in various law firms, all in Oregon, and eventually got nominated by Joe Biden and was confirmed. I'm not worried about Judge Sung on this panel. And then you've got the middle, which is where I think the advocates that argue before the Ninth Circuit, and I've had the pleasure of arguing before the Ninth Circuit in San Francisco, in that courtroom, at just that they're going to do tomorrow. Not with this 3-judge panel. Actually, I had a completely different 3-judge panel. But Judge Bennett would be, for me, who I've got to target. I would say, I don't want to write off Miller. You never write them off. You try to bring them in, but then you aim for the center. And Bennett, although a Trump appointee, came out of Hawaii, which is generally moderate. It's always been blue. It's been voting for Democrats forever, not starting with Kennedy, but as far back as Kennedy in modern history. And he was the attorney general in Hawaii and took a lot of interests that were opposed to the Trump administration, a lot of pro-immigration, a lot of pro-environment. And he has been his own person. He is at best a moderate Republican. We used to call them a country club Republican, not MAGA. So as an advocate, when I just tell you how I prepare for an oral argument. And so that's, I'm sure, that California on one side, argued by the appellate specialists for the Attorney General's office, maybe Rob Bonta, the Attorney General himself, are going to be arguing for California. For the lawyers for the Department of Justice, it could be Brett Shumate, an assistant U.S. attorney from California, or it could be an appellate specialist in the Department of Justice's office, to the extent there are any of those left. And the issue so let me go back to the mechanics. So you have your panel. They've read your briefs. This is now time, usually for a hot bench. They let you get out about a minute and a half, maybe 2 minutes of your presentation, or they jump right on top of you within the first second. And you then have to hold on for dear life. Know the 3 or 4 points that you need to make before your time is up. This is scheduled for 30 minutes, 15 minutes aside. It'll go longer. It's up to the judges. It could go an hour or so. It could go an hour and a half. But you got to hold on and be able to check the box of the 3 or 4 things that you need to make. But you need to do it in response to questions being asked by the panel. So you need to be able to answer and pivot. You need to answer their question. And if you can work in your position, the point you need to make, all the better. But if you can't, then you got to find a way to pivot. And if they ever stop hitting you with questions, go back to your list. So by the time you sit down, you held on to something. You were able to make your presentation through their questions. It's almost like a press conference, but you can't ignore the judge. You have to answer the question, yes, but, no, but. You can play judges off each other. Oh, well, as Judge Bennett just said, well, that's a very interesting question, Judge Miller, because Judge Bennett's question, and you can do that. But we're going to see who's going to be sitting. Normally, the highest ranking, the most senior person sits in the first seat. I think that's going to be Bennett, which is where you would aim. If for some reason they've decided to rotate the panel because they sit for more than one appeal, maybe Sung is sitting in the lead chair. We'll see. My gut is it's going to be Bennett in the lead chair with Miller and Sung up on the panel with lights that tell you how much time you have left. And also if you are the movant, if you're the party making the argument, which is the Trump side, you then get a couple of minutes in rebuttal. And it's up to the judges to decide how much rebuttal to give and if they're going to give the other side the last word as they continue. From there, they rule. Now, the Trump administration has taken the position, well, they're going to rule any day, but there's no requirement that they rule any day. They set a briefing schedule, yes. But how long it takes them after that to write their opinion Could be 3 days, could be a week, could be a month or more. And in the meantime, the status quo stays in place, which is the status quo of the injunction the injunction is blocked, meaning Trump is still in charge of the troops in California. That's where it would be left while we're waiting for the response. So that's how you advocate. Now, there's a long line of cases at the Supreme Court that support California's position, that Donald Trump violated the 1903 Militia Act because there wasn't a rebellion, as that term is used in 1903, that there wasn't he's not prevented from enforcing the law, and he didn't go through the California governor to issue his order. So with that in place, and the line of cases that are out there at the Supreme Court level about when a president can or cannot commandeer a state militia, California should win. Now, while that's going on Tuesday, on Friday, there's going to be a hearing in front of Judge Breyer. I just did a prior hot take on it. You can go look it up, about the next level of injunction called a preliminary injunction, which would stay to the end of the case. And Judge Breyer looking carefully at whether over the weekend, maybe on the day of the No King's Day, there was an arrest or detaining by the U.S. military in violation of the Posse Comitatus Act, which stops a president from using the great, awesome force of the military against Americans, turning the military internally instead of externally to protect the homeland, whether that happened. And the judge suspects that it happens because of the order that he just issued that I just did a hot take on. So Friday, even though this is going on in the parallel world of appeals about the first step in the process, the temporary restraining order, the preliminary injunction is Friday. One of the first questions we may see from somebody like Judge Sung, but it could be Judge Bennett too, is why are we here? They did grant an administrative stay for 72 hours, but that doesn't mean they're going to grant the ultimate stay. And the why are we here question is a jurisdictional question, because generally, appellate courts don't have jurisdiction over temporary restraining orders because they last such a short amount of time. And the thinking is, all right, the temporary restraining order is only a few days, maybe a week. You're going to have a preliminary injunction hearing, right? Then you come to us. So one of the first questions is going to be, we understand there's a hearing on Friday in front of Judge Breyer, and you're all going to be at, and you've all briefed. Why aren't we waiting for that? Why are you in this courtroom now asking for a continued stay? How will you be harmed if we keep the administrative stay in place, but we wait until the preliminary injunction so that we do one appeal? How are you harmed? That's where I would go. We'll know right away, and you'll know right away if you join us here on Legal AF for the live feed of the oral argument, the Ninth Circuit. There's no television or YouTube, but there is oral argument and a live feed of it, and we will have it here on Legal AF. Join us tomorrow, but in the meantime, hit the subscribe button as we try to get to 700,000 subscribers before this month is over. We will, with your help, I guarantee it. And then set the reminders for all the new work that we do here at the intersection of law and politics. Until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.